Hello, everybody. Hello. Thanks for joining us. Almost forgot to put my microphone on. Great to see you. We've got a popular topic today, more of an estate planning topic, how wealth transfers. So this one is really an eye opener for a lot of people and helps them understand whether they need a will-based plan or a trust-based plan. So let's dive in. First thing, as always, the Foundation for Personal Financial Education is the nonprofit organization we run here in the Valley. It's nationwide and been around for 20 years. The whole idea of this organization is to be able to do the financial education without the sales or the bias that we see going on out there and all those wonderful sales events like dinner seminars and all the other gimmicks that are going on out there. So be very careful. I am a true believer that any type of investing or things like that should not be sold as products. This should be where financial planning comes in and properly placed things like your estate planning tying in with all your investing strategies and funding your retirement. So be careful about the sales world out there. It's everywhere. It's not just in the financial advisory. It's lawyers. It's car salesmen. It's everything out there. So just be careful. Make sure that you're getting advice that is right for you and your own situation. Legal disclaimer, everything we talk about is for educational purposes only. Please utilize your CPAs, financial advisors, attorneys to figure out exactly what is right for you in your specific situation. This is general knowledge. This is what you should utilize to work with these advisors. All right, so you either need a will-based plan or a trust-based plan. That is a fact. It helps your heirs. It makes things transition smoother. We need to make sure that we've got documentation on either side taken care of. So a will-based plan has your last will and testament, tells everybody what to do with your stuff and who's in charge of your children if you have any. Living will says pull the plug or don't pull the plug. Donate my organs, do not resuscitate, all those types of things they talk about in the living will. In Arizona, we have two medical power of attorneys, and collectively they are the advanced medical directive, and then the financial power of attorney. And what you'll notice is the trust-based plan is very similar. The last three are the same as the last three over here. The only difference is the last will and testament is switched out for what we call a pour over will. And that simply says whatever we forgot to put in the trust, please put in the trust. This will only be used if you're in probate. So just as many people go into probate with trusts as do with wills. So just be careful about this. You got to do everything properly on both sides of this. Otherwise, you end up in probate. And then there's the revocable living trust. All right, so you heard me right. If you do everything right, a will-based plan or a trust-based plan, you should not end up in probate, okay? Probate is not scary if you have documentation. It is scary if you die with nothing, okay? That's what we have to be careful of. So now, how property transfers if you just have a will? And this is where it's really important. I'm going to go very slowly through this. The first thing, priority number one, property titling. Okay, so real estate, bank accounts, cars, who owns it? What is on the ownership paperwork? Okay, which is typically all monetary accounts have ownership paperwork. All cars have ownership paperwork. All houses have ownership paperwork. So if an owner is still alive, there is no probate, okay? We just move on. Nothing really changes if an owner is still alive. That's the titling. Done, we move on, okay? So no probate. Surprisingly, beneficiaries is number two. This is the legal priorities when it comes to transfer of wealth. Notice this, beneficiary designations avoid probate if direct beneficiaries are properly listed. Well, let's explore this one. In the state of Arizona, real estate can have beneficiary deeds. Okay. So you can put a beneficiary on all your real estate in the state of Arizona. Cars. The motor vehicle department allows you to put a beneficiary on your cars. Okay. Money. Every monetary account, including bank accounts, Roth accounts, IRA accounts, 401k accounts, every monetary account out there, and life insurance policy, annuity, all of that stuff allows you to put beneficiaries directly on the account. I'm going to let that sink in there. Okay, so I just told you that your house, your car, and all your money can have beneficiaries. And it clearly said here, avoids probate if direct beneficiaries properly listed. What do you have left? You can have a will-based plan, and we haven't even got to the will. You can have a will-based plan and avoid probate on your car, your house, and all your money. So what are we really worried about? If you do this properly, if you make sure that every account has beneficiaries listed, that's as easy as transferring wealth can get. Okay, this is the simplified, easy way to pass everything to your heirs. So if you have a simple family and a simple situation, my parents have 2 kids, and they're going to split it 50-50, boom, they split it up 50-50. Each account has in our case, it's a son and a daughter, 50-50 ownership of each account or beneficiary of each account. Okay. That's all you got to do. Make sure you own things jointly with a spouse. Make sure your beneficiaries are listed properly on every single account. And then anything left over will be instructed by the will. So the clothes, the furniture, the jet ski, which still has licensing, you could probably put a beneficiary on that. So just understand the will really just cleans up the stuff at the end, and you don't need to go through probate for that. Okay. So this will go to probate if you forgot about a bank account with 100 grand in it. Okay. Then you end up in probate, but that's after everything else is transferred. The probate is literally just to get that money out. That's it. Okay. So it's good to have this will in case somebody messes something up late in life. All right. And then gifting is the lowest of all priorities. Any gifting you do that conflicts with this can cause legal arguments later. So be careful about that. Don't start gifting to the great grandkids or the grandkids and make it different than what you were planning on doing with your beneficiaries and your wishes and your will. Okay. So if we have an IRA and the will, you just happen to list it in there and it says, the will says the IRA is supposed to go to the son, but your beneficiary on that IRA says it all goes to the daughter. Question is, where does it go? Well, this is legal priorities here. So whatever the beneficiary says goes. The will is wrong, period. Okay, so the beneficiary has legal priority over the will. It's very important that we understand that, and that's why these first 2 sections really make or break the transfer of wealth for your heirs. If you do these properly, your heirs will thank you. You'll be gone, but your heirs will thank you. Okay? Now, how's a trust different? Well, the big thing about the trust is everything that we can put in the trust should be in the trust's name, meaning the trust should own your bank account. It should own your house. Any money it can own, it should own. That should be the owner of everything it can be, because when you pass away, if the owner is the trust can't die. Therefore, there's no probate. Okay. Then there's plenty of things that you can't put in the trust. So primarily it's the IRA and the Roth accounts. IRA and Roth accounts, I highly recommend you put beneficiaries on those that are human beings. If you're married, you put your spouse as the primary. and then your children or heirs as the contingent beneficiaries. You want human beings on there so there's no mix up and no problem and no big, huge taxation by accident, okay? So please, please put your direct human beneficiaries on your IRA accounts and your Roth accounts. You can bypass the trust on those, but nothing else, okay? Then there's the trust. The trust says what to do. You have that pour over will. If you forgot to do any of this properly, you got to go to probate. You take the pour over will in there, and they will push any of these assets right into the trust. Okay. So again, if you don't do the top two properly, you're going to be in probate, and you'll have to pull out that pour over will and take care of transferring those assets into the trust. Okay. And then gifting is, again, one of the worst things you can do late in life. Be very careful about the gifting that you do late in life. All right. So you can see pretty much the same process to go through in each case. These two become the most important thing in each case. And if you do these properly, you won't be in probate. Whether it's a will or a trust, it's the same thing. You've got to do these two things properly. All right, so let us know if we can help out. We do a lot of beneficiary reviews here. We can jump in, help out, make sure that you've got things taken care of. There was a study done a little while ago of beneficiary accounts. They went through a bunch of major investment companies and reviewed beneficiaries, and over 70% of them were wrong and would end up in probate. So make sure you review these with somebody that knows what they're doing, and certainly if you don't have that, more than happy to help out. Give us a call, contact us at sesweb.net or phone number 800-345-3155. Nonprofit requires I give you at least an hour of my time. I'll meet with you as long as you need, especially during all this COVID stuff. We got a lot of time on our hands around here. So jump on, let us know if we can help, and we'll see you next week. Thank you.